Good morning, everyone, in History of the Constitution. I'm going to put up a quick video about the Fourth Amendment and put up a couple of assignment about the Fourth Amendment as we move forward. We want to get through all of the amendments before the end of the semester and kind of gel some of the other characteristics of the Constitution in a sort of a holistic package before we wrap up the semester. But it's ending fairly rapidly. We're on the eve of Thanksgiving. I wanted to put up an assignment for the Fourth Amendment. I was thinking about putting the Fourth, Fifth, and Sixth Amendments together in one package, but there's so much material there. I want you to understand these concepts. I know a few of you might be a little frustrated and saying, how come we're not going through all the amendments? We've covered the First Amendment about the freedom of religion and also the Establishment Clause that government can't recognize a formal religion as its own. And also freedom of speech and freedom of assembly and freedom of the press. We covered all those major concepts. And how come we're not doing the Second Amendment, Third? How come you're skipping some of them? It's not that I don't think they're important. I just think in terms of everyday experiences, you're more likely to have dealings with the First, the Fourth, the Fifth, the Sixth, the Eighth. And that's the core essence of the Bill of Rights that really permeate our daily existence. I'm going to mention the second right now, just to put it to not to rest, but just to suggest that no right in the Constitution is unlimited or unfettered. There are parameters to all of them in order to keep society protected and sane. So the right to keep and bear arms in a well-regulated militia has meant more than what you and I might think of as a militia, because we know at the inception of our Constitution, a militia was basically citizenry, people that would get up and volunteer to participate in civic duty. So the courts have interpreted that the right to keep and bear arms is largely an individual right, but how far does it go? Can you possess any kind of arm that you want? No. We know the government does have an interest in making reasonable parameters to that. What is reasonable? Goes back to judicial review, Marbury versus Madison. It's the court that tells us how far the government can go in curtailing or limiting the nature of a right to keep and bear arms. But generally speaking, nowhere can it just be banned outright. It has to have a rational basis for why they do so. So there's constantly a new ebb and flow about how far states, local municipalities, and the federal government can go before the court says it goes too far. It's in breach of the Second Amendment. But we know certain people who have been convicted of violent crimes can be barred from possessing and owning weapons. We know people that maybe are currently suffering from certain kinds of mental illness that make them a danger to themselves or others might be barred. We know that certain weapons, because they can inflict incredible amounts of carnage, can be limited to only certain people or banned completely for civilian use. Fully automatic weapons, for example. Although there are some exceptions on that, even in Massachusetts, you can actually have a machine gun license for certain fully automatic weapons that were manufactured before a certain date, but it's a special license rarely given out. But you get my point about the Second Amendment. It's not an absolute right to own any kind. I can't own a small nuclear device if I want. I can't have chemical weapons, for example, and I might not be able to own a weapon in Massachusetts, at least with a certain capacity. Well, why Massachusetts? I thought that was the Second Amendment to the United States Constitution. That Second Amendment places a ground floor upon which states can't go below, but states differentiate themselves about how much control they want to put in regulating weapons. Very challenging situation when it comes to federalists. And that's why we're going to go into the Fourth Amendment now, talk about the dichotomy between the Fourth Amendment, and I'll use Massachusetts as an example, under what we call Article 14 under the Massachusetts Declaration of Rights. They're nearly identical in terms of language. What's the Fourth Amendment all about? Fourth Amendment is trying to keep us as citizens free from unreasonable searches and seizures. I'll just read the amendment out. It's in your book. It's easily accessed. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. That's just to be stopped, for example. That's a seizure. Or your stuff to be taken. That's a seizure. Shall not be violated. And no warrant shall issue but upon probable cause, supported by oath or affirmation, which means you have to go in front of a judge or a magistrate to get it issued. You need that third party, that sort of neutral set of eyes, in order to determine whether or not there's probable cause. In particular, describing the place to be searched and the persons to be things to be seized. Why did they do that? The framers were getting upset because the British government were searching people that they were basically suspicious of, and for no other reason, really as a tool of harassment. And they would search everywhere, your business, your home. They would stop you on the streets. We didn't want that. We wanted, when government was going to seize us, interfere with our personal movement and freedoms and search our things that we have an expectation of privacy over, we wanted the government to have a warrant in most circumstances. And when there wasn't a warrant, they have to have justification why they didn't have a warrant. So what does it mean to be free from unreasonable searches and seizures? Again, it's up to the courts to tell us what's a violation of the Fourth Amendment. Many of you, I'm a big privacy advocate. I don't think the government should be able to look into my personal papers and effects, phones, person, clothing, my home, my office, unless it's very, very much supported by proof that there is either criminality going on, therefore they must seek a warrant, or that there's an exigent circumstance that they must do it to preserve evidence or save lives. I'm very libertine on this issue. I don't like my government being able to search my car, for example. Like, say I got pulled over tonight, and they say, I'm not too busy tonight. Why don't you step out of the car, sir? I want to search your motor vehicle. That upsets me greatly, and that's why we have things like the Fourth Amendment. Now, I can't give you I probably could give you an answer to most of them because I'm a criminal defense attorney, but these things that when can cops search? When can the government interfere and look into our phone, for example? When can they do all these different things? It's derived by court law. Sometimes by statute in some states, they'll actually outline when it's appropriate. Now, that's the Fourth Amendment. And what do I want you to know for the test? The Fourth Amendment, up until recent history in the 1950s, was not applicable to state action. And those of you that are current criminal justice majors or interested in becoming lawyers or paralegals, and you're going to work in an area, it's an amazing phenomenon that the protections from unreasonable search and seizures didn't apply to state action. What do I mean by state action? Meaning that if it was a criminal prosecution by the state police, the local police, the city police, the Fourth Amendment had no applicability. This shocks most people to know that this is the history of the Constitution. That's why we're going to discuss it. The Fourth Amendment was only a limitation on federal government overreach. So really the FBI, and now we have Homeland Security, we didn't have it in the 50s, it only applied to those groups. But what happened was there was a process by all of the Bill of Rights slowly being what we call incorporated, and that's what's on the test. What's this doctrine of incorporation? The 14th Amendment, which was created in 1868, really wasn't looked at until the 1950s, really for purposes of the Fourth Amendment. They started saying that no state shall deprive its citizens of due process of law and equal protection of law. That's come to be interpreted to say, well, what is a fundamental right? What is those inalienable rights that the state can't deprive us of without just cause? And they finally came around and said it's the Fourth Amendment as well. So now, most people want to know, well, what's going on now? I don't care about the past, but you didn't know about the evolution. Now, all government is subject to review under the Fourth Amendment. Was their conduct a breach of the reasonableness standard under the Fourth Amendment? And many of us disagree what's reasonable. I'm very liberal on this issue, or libertine. I don't like my government being able to look into my things or anybody else's things without strong justification, because that's what keeps us free, knowing the government just can't go do it willy-nilly. Other people say, well, wait a minute, doesn't the government have interest in protecting its citizens from crime and violence? They should be able to ferret out crime by searching people that are suspicious or, maybe unusually suspect by being not usually seen in the neighborhood and things like that. I know a free society isn't always a perfect society. In order to keep us free, you know who's going to be searched. Poor people, people of color, people with less nice looking cars than others, younger people. I don't like that. I want equal protection law, and things like the Fourth Amendment keep us free. Now, what tells us, what does the Fourth Amendment mean? When is it reasonable and unreasonable? It's all court derived, and that goes back to Marbury versus Madison. So whether something's an unreasonable search and seizure is determined by the Supreme Court or the federal court as to the Fourth Amendment. But most of our cases are criminal. Those of you that are CJ majors, you might be surprised. 95% of all criminal cases that go through the court system are state, meaning it's your local Worcester District Court, Springfield District Court, or we call it Hamden District Court. Those are almost all state derived. Very few are federal, although we have federal courts in the state of Massachusetts, much narrower niche. the federal government only has to comply with the Fourth Amendment to the United States Constitution. But what do those local and state police have to comply with? Not only the Fourth Amendment, because the federal government places a ground floor level of what's determined to be reasonable and unreasonable. So can you get greater or different rights under your own state constitution? Yeah, that's the system of federalism. It really complicates things. So I'm going to post on our Blackboard section a copy of the Fourth Amendment and a copy of Article 14 of the Massachusetts Declaration of Rights. Almost word for word the same. So shouldn't they mean the same thing? There are jurists, lawyers, and judges that do make that argument. They should really mirror each other in terms of meaning. Sometimes they call it the lockstep approach. The federal standard should be the same as the state standard. They were adopted within 10 years of each other. They served the same purpose, a check against unwarranted, unreasonable searches and seizures by government. They should mean the same thing whether in the state or the federal realm. We haven't gone that route. Massachusetts interprets its Declaration of Rights more liberally, more for the protection of the citizens from unreasonable searches and seizures. So I can get evidence potentially challenged as a violation of Article 14 of the Massachusetts Declaration of Rights more successfully than potentially under the Fourth Amendment to the United States Constitution. I always cite both when I'm trying to throw out evidence to make an argument that the government's violated the constitutional rights of my client. It might be the state rights because they're looked at more in a liberal fashion to protect citizens from unwarranted searches and seizures. But if you look at the rest of the amendment, it says no unreasonable search and seizure shall be allowed. Persons, papers, places, effect. That means all your stuff, including electronic devices. However, it says no warrant shall issue but upon probable cause. The courts over time has told us what probable cause means. It means that there's a likelihood, a probability, that based upon objective, observable facts, law enforcement has articulated grounds to believe it's likely that a crime is being committed or illegality is taking place in a certain area and it should be seized or searched. But it has to be done under oath. And when they do it under oath, that obviously means it has to be presented to a third party, and that's the court. And the court arguably is neutral, right? They're going to take a look at it and say, officer, this information you're giving me is just junk. It's all based upon conjecture and guesswork. It's inappropriate, or it's inappropriate. Like you're saying, I should be able to search a person because they're African American or because they're Hispanic. That's not a valid reason to be able to search somebody. It's a violation of the Constitution, isn't it? Also, sometimes police officers, but in good faith, come forward and they say, I've got this information, and the judge might say, well, when did you get the information? Oh, I got it like 2 years ago. Well, now the information is stale. And so we need reliable information to be presented to a neutral, detached magistrate, and it has to rise to the level of probable cause that there's criminality taking place or a crime's taking place, and therefore an arrest warrant or a search warrant can issue. Now, the thing I do like about it too, that's kind of a fun topic, it says it must describe the persons or places to be seized or searched and the things to be seized with particularity. What does that mean? If you're looking for a shotgun, guess where you won't find it? You won't find it in my cell phone, right? So you don't need to look through my emails and my text messages for looking for other criminality, do you? If you're looking for a shotgun, you're not going to find it in my briefcase. Well, maybe my briefcase, I guess. Maybe I should have put my wallet. I don't even have a wallet, but if I had a wallet, I could say you couldn't find it here, or this pencil box, right? If you go searching through there, you wouldn't have found a shotgun in there. Why? Because we're trying to avoid harassment by the government. Because if they're looking for a shotgun, they shouldn't be able to look through my pants pockets because I can't fit a shotgun in pants pockets. So, and also the persons to be seized. If they say anybody that's in the house, well, that is a very general search warrant, and it's subject to challenge because it didn't particularly name the persons to be seized. You don't want these carte blanche, wide open fishing expeditions by the government because people would be harassed otherwise, and it would really be a violation of our sense of inalienable rights to be free in our privacy interests. So I don't always know when it's reasonable. I have a lot of familiarity with the case law dealing with searches in cars, searches of persons, searches of homes. The area that's most considered to be sanctimonious, meaning that the government really has to substantiate its burden, probably has to get a warrant, is searching a home. And why is that? Our privacy, and that's how we measure it, and that's how the court measures it. They look at what we have as a privacy expectation. Is your privacy expectation much higher in your home than it is in your locker at school? Yeah, probably much higher. Or in your car. Yeah, there's a gradient scale. Depends on where it is. I think this, and there's some case law that came down, and I think it's pretty favorable. is that this phone, my phone, your phone, we have a very high expectation of privacy, don't we? We do. There's a lot of information going back to loved ones and people that you're in relationships with and work and you talk about a lot of things you wouldn't want the world to know about. It's almost as private as your home. So this has been held to a very high standard. I think the court got it right that in order for the government to search that, they probably need a warrant unless they can show it's an emergency, and it has to be supported by probable cause and what they're looking for and why they're looking for it. I think that's a good area of law. Now, many of you say, well, do they always have to have a warrant? And most of you probably already know instinctively, well, no. Well, think about it. If every time you pull over a car, and I think, geez, these people are acting very suspicious, they're not from the area, maybe they're looking like they're tucking something under the seat as I come up to the car, they don't give me good answers, the defendant that's driving the car has a long criminal record, I'm in an area where there's a lot of drug activity, and all these things I think add up to probable cause. If I had to go and get a warrant, it would be an unreasonable delay in basically the function of police work and mobility of cars. So there, because I have probable cause, I would be able to search in the moment, but it would be up to me to justify it as a police officer later in court. Anytime there's a warrantless search, it's up to the government to prove it meets an exigency. It's an emergency. It's something that takes it out the realm of the reasonableness of getting a warrant. I always use the example when I teach this class traditionally in a traditional classroom. You guys are all sitting in class. Imagine cops walking a beat in downtown Worcester near the three-decker areas, and some woman's hanging out the second floor screaming, "Oh my God, he's stabbing me! He's stabbing me! He's going to kill me!" Do you really expect the officer to say, in order for me to go in and search that apartment, I better go get a warrant? No, because the exigency of the circumstances suggested the reasonableness to go in there to protect human life and safety. Now, how about this? What if I'm chasing a drug dealer? I watch drug transactions through binoculars. I'm familiar with the packaging. I know the defendants in the view through my binoculars, and I clearly see them engaging in a fairly large drug transaction. Now I'm going to get the person who just bought the drugs because they're buying it off of a confidential informant that I was working with. I go after them. They start running. They go run into their apartment up the stairs. Oh, I can't go in there. Yes, you can. It's an exigent circumstance. And when is it exigent and when isn't? It's up to the courts to tell us when it's reasonable and not reasonable. And those of you that like this stuff and are going to go into law school maybe, or you're going to be a paralegal, or you're going to be a cop or probation officer, these rules are always in flex and they're changing all the time because judges change on the court and there's an evolution to these rules. Massachusetts stays, and some people don't like to use the term liberal because it suggests a certain connotation politically. But what I mean liberal in the sense that we do tend to err on the side of protecting privacy interests. The government has a pretty heavy burden showing why they had a right to search the defendant in certain circumstances, whether it's your person. And I'll probably put up two famous cases for us to discuss and have a couple homework assignments. One's Terry v. Ohio. Think about it. When an officer just sees somebody acting suspicious walking down the street late at night, it's 2 o'clock, some people looking inside of a store window that's closed, they act nervous. Anytime I'm driving by in my cruiser, they seem to duck into an alley. They're not running or anything. And, they're very, very suspicious. And then later I decide to park the car and kind of walk the neighborhood. And I see these two guys again. They look like they just look very unusual. And it's late at night. And it's a high crime area. Would it be unreasonable for me to go up to them and talk to them? Yeah, they don't necessarily have to talk to me back. But what if during the period of time I'm having a conversation with them, my concerns are not alleviated and I become concerned that they may be armed and dangerous? I don't have proof of it yet. But would it be unreasonable for me just to pat down the outside of their clothing for my own protection and that of the public around me for a potential weapon? Well, now I'm patting them down and I feel something hard in their top pocket. Could be a knife, could be a gun, I don't know. And then I reach in, turns out to be a square metal can, maybe 4 inches by 4 inches and maybe 1.5 inches thick. Could that have a knife in it or, maybe a small gun? Well, it might. All of a sudden I open it up to see if there's a weapon in it. And what do I find? A quantity of cocaine or quantity of heroin wrapped in little baggies. That's what happens quite a bit. And the question is was my initial stop of that person standing on the road and my pat frisk of the outer part of their clothing leading to more concern because of what I felt inside? Does it allow me to go in and search further? These are the kinds of cases I deal with all the time. And I shouldn't say hate to say it, but I can tell you that a significant amount of my cases are, one, not on the merits of whether or not my client was possessing drugs or a weapon or illegality. It's on whether or not the police searched appropriately. Because here's the second thing that I really got to stress. Whether it's a search of a person, a car, a home, what if we determine, or a judge determines, that it violates the historical mandates of our courts as related to search and seizure? It's a violation of either the Fourth Amendment to the United States Constitution or the state constitution. What do? Most of you already know intuitively what we do. We throw out the evidence. Where does it say that anywhere in the Constitution that we suppress the evidence as fruit of the poisonous tree? Some of you might have heard that term before. It comes from case law. The rule comes from case law, and that's why the rule can change over time. Nowhere in the Constitution does it mandate that illegally seized evidence must be suppressed, must be thrown out of court, must be banned from consideration. That is a court-made principle, and it's not favorable in a lot of justices' eyes. And I got to admit, on the federal level, it's gotten eroded substantially. In fact, now under the federal level, what we call the rule of fruit of the poisonous tree, or the suppression of evidence rule, it's almost dead on the federal level. You almost have to prove that the police, law enforcement, knowingly violated the Fourth Amendment. But if they do it in good faith, the federal courts have been more and more, it's a case called, I don't want to get too deep into it, but it's called Herring. In fact, somebody wrote an article about it not too long ago, because I'm in this area in criminal law. They wrote, the stench of herring now pervades federal criminal practice. Herring's also the name of a fish. And why do they think it's a stench? Because basically the Supreme Court of the United States has said recently, in the past 10 years or so, that under Herring, if the government doesn't look like they did things in bad faith, just a mistake when they violated the Fourth Amendment, the evidence should still come in to be used against the defendant. I don't like that. If you violate the Fourth Amendment, I don't think the evidence should come in, because I don't know what the other protection is that we get. What can we, in the Supreme Justice Scalia, who passed away a few years ago, he always said, nowhere in the Supreme, in the Constitution does it say evidence should be suppressed that's otherwise valid. The evidence is real. It wasn't put on the defendant. The defendant had it. It proves guilt of something. It is legitimate evidence. It's just discovered illegally. I believe the evidence should be thrown out. Why? Because other members of the court system, like Justice Scalia, says, wait a minute, there's other remedies for the defendant. They can sue the cop for a civil rights violation. But who do these people tend to be? They tend to be poor. They tend to be disenfranchised and not know how to use the legal system that way. They don't have the money to hire civil attorneys to sue for their civil rights violations. So the only way we've really effectively learned to deter police from not doing illegal conduct in their own name is meant to suppress evidence as fruit of the poisonous tree. I think it's here to stay for a while in Massachusetts, and again, 95% of all cases are criminal from the state. It's the state constitution that's going to still allow for the suppression of the evidence. What will happen on the federal level? In order to suppress evidence, you almost have to show that the police department or the FBI or whatever federal agent found the evidence. They did it in bad faith in some way. Very, very tough standard to prove. So you do need to know about the suppression of evidence case, and we do need to, I'm going to put up Mapp v. Ohio, which is the first case that decided to apply the Fourth Amendment to state action. It was a game changer. And Darlene Mapp got her house searched because she had a tenant that was living there, and the tenant may have actually been some kind of hit person for the mob, and tried to blow up someone's house. And if anybody knows a little history about boxing, the house that was blown up was a guy by the name of Don King, the big boxing promoter. I don't know if Don King's still alive, but they blew up Don King's house. Some tenant of Darlene Mapp was the target of the investigation, and they searched the house without a warrant, without probable cause, just like kind of on a hunch. And they didn't find anything related to this whole bomb making and terrorist activity against Don King, the boxing promoter. But what they did find was arguably some pornographic material. They were talk about what pornography has changed over time. These were hand-drawn sketch of naked women, like in pen and ink. And Darlene Mapp challenged the conviction of possessing pornography based upon the First Amendment, freedom of speech, artistic renditions and things like that. And it went to the Supreme Court on that question, but the Supreme Court on its own accord decided to take up whether or not the search was unreasonable. And three of the dissenting judges said, wait, it doesn't matter, because this is a state action. And if the state doesn't follow the Fourth Amendment, that's okay because the Fourth Amendment only applies to federal action. There, the Supreme Court said we got to start incorporating the Fourth Amendment to be applicable to state action. And that was a game changer. I think most of you that want to be cops or interested in law enforcement or just interested as a citizen know that that's usually the outcome of a case. When the cops violate your rights, there's ramifications. And the big one is usually they can't use evidence seized against me. And that's going to relate to the Fifth Amendment with confessions. In order for a confession to be valid against me, it must be done voluntarily and freely. So in order to ensure it's done voluntarily and freely, you must give me the Miranda warnings in order to preserve the Fifth Amendment privileges, the warnings, if you will. I love the Fourth Amendment. I think it's something that really does keep us free. And some of you are going to say, and I can't really argue with you because there's some truth to it, who's it really keeping free? Is it really keeping everyday citizens free, or is it keeping criminals free on a technicality? That's what people like to argue about. But the reality is if we erode the rule for those people that seem like they're being protected by it, criminals, the government will start abusing the principle against the unpopular, against the poor, against minorities without repercussions. So if the law knows they have to comply with this principle of privacy and that it's protected in the Constitution, I think it keeps a better society. It keeps a civil society, one in which we really maintain freedoms for everybody. And I know the application of the rule tends to trickle down to people involved in criminal activity. It's really designed to preserve the principle for all of us in a very big way. So trying to keep this video somewhat short, but take a look at the Fourth Amendment. I'll put up a little video too, not of me, but there's some nice discussions on YouTube videos from scholars about Mapp v. Ohio and the suppression of evidence rule. And I'll put up a question, is that the best remedy for suppressing evidence? And what are the factors and the elements that should go in to determining whether a privacy interest is in play, because that's the first test. And secondly, whether the government acted unreasonably or reasonably under the circumstances. And it's nuanced. I'm a very big privacy guy, so I think, there's always a privacy interest. And I also think the government has a very high standard to prove their need to be able to seize something or search something. Others are saying, hey, but we have to get behind government. They're there to do things in good faith, to ferret out criminality. And if we hamper them so much, crime's going to be out there rampant, and we'll live in an unsafe society. And I can tell you this, the principle of what's reasonable and unreasonable has definitely changed since 9/11. Think about it. Now, when you go to the airport, you have a much lower degree of privacy expectation in your luggage and your person. Yeah, you're basically stripping down. You're going through an infrared thing. They're pat frisking you because the expectation of privacy has diminished to protect society from terrorists going on planes and things like that. And so we ebb and flow over our views of what's reasonable under the Fourth Amendment in terms of the privacy interest and whether or not law enforcement has acted reasonably or unreasonable. Court-made rules that can evolve and change over time. Have a good Thanksgiving if I don't talk to you earlier.